All right, you guys, welcome. I want to welcome everybody today. We're going to have some discussion on some stuff. You guys like stuff, right? We all like stuff. Give me just a second. All right, guys. I just had to make some revisions here, and I'm going to turn this off right now. Okay, so I'd like to Tostito first.
The following program contains mature content and is the truth. No part herein is intended to be legal advice and is for entertainment purposes only. Audience discretion is advised.
Whoa, that was weird. I had a cord that fell on something, and when it fell, it made that noise. Okay, so anyways, today we're going to talk about some interesting stuff. Actually, it's pretty interesting. Let me move some windows around here so you guys can see, or so you guys can follow. Now, I don't really have, what I'm going to do is I'm going to put up a picture just so my mug isn't up here, but I'm going to find something to give you guys a slide or a picture or something. Let's see here. All right. You know what? Okay, so I can't put some of this stuff on here. I want to show you guys some stuff, but I can't put some of it on here. Anyway, okay, I'm just going to leave it just like it is. I'm going to go over some things with you guys today. We're going to talk about primarily, well, let me get my screen back up here again. We're going to talk about a specific trust issue that happened. It was back in 2013. And then we're going to talk about how it's related to some other things. So the trust litigation is complex, and there's a lot of different things that are related with it. And well, a lot of times you guys know that you probably had someone passed away, or, you've had a family member that, passed away, or know of somebody that has, and it can be like a really emotionally charging issue. Well, this case is called Kin versus Tyler, and it's a prime example of the challenges in this, and it highlights issues that are related to what are called no contest clauses. These are amendments that are obtained through undue influence, where someone's like influenced to do something without any justification. So, or the broader implications for estate planning and trust administration. So we're going to go over and provide what I can give you as far as an in-depth understanding of the Key versus Tyler case and how it was significant in trust litigation and its historical precedents. So the other thing, this analysis that I'm going to give you is going to explore maxims of equity that apply to the cases and illustrate the evolution of trust law over time. So then we're going to talk about some other things regarding maxims, but the background of the Key versus Tyler case is revolves around a dispute over a trust amendment that significantly altered how assets were distributed. And the original trust, it included a no contest clause that intended to deter beneficiaries from challenging the terms of the trust. So Tyler was one of the beneficiaries, and he defended an amendment to the trust that was allegedly obtained through undue influence, leading to a huge legal battle. So the court examined in the case the enforceability of the no contest clause. Ultimately, they determined that the case in Tyler's defense of the 2007 amendment violated the clause. His defense of the 2007 amendment violated the clause. That decision, it resulted in his disinheritance under the original terms of the trust, which did not include the amendments she attempted to defend. Okay, so the original trust document was made with meticulous detail and was intended to distribute the settlers' assets in a manner that reflected their intentions. But integral to this trust was the no contest clause. And this is a provision designed to safeguard the settlers' wishes by deterring any disputes among the beneficiaries. So it gets rid of the disputes. The clause stipulated that any beneficiary who contested the trust terms gives up their inheritance. So basically, you want to call them about it? Okay, see ya. You want to call them about it? Okay, see ya. Anybody else want to call them about it? And everybody just stays shut, right? Because like people are dropping off like flies. So trust, the controversy in the trust, it began when Tyler presented a 2007 amendment to the trust. And this altered the distribution scheme. This amendment was purportedly made under circumstances suggesting undue influence. And undue influence in legal terms, it involves exerting excessive pressure on the settler, thereby compromising their free will and resulting in an unfair benefit to the influencer. So the person that's influencing them gets a benefit over the person that they're influencing by, it's like intimidation, right? You ever stood over somebody, or maybe you've made, or maybe you know of somebody who's made accusations about somebody else, or pressuring other people to follow a certain thing, because, just because, they want to have control and power over other people. That's just human nature, and that's an ego thing. It's essentially a spirit that has been traumatized, that has not healed, and so they go around and continue to harm and heal other people. So that's really anybody that has negative things to say about other people. That's what they are. They're hurt people that haven't healed yet. So we work on helping them to heal in whatever way we can. So in this case, the court scrutinized the circumstances under which the amendment was obtained, and they concluded that it was a result of undue influence. They acknowledged, yes, it was a result of undue influence. So no contest clauses, talking about that on that subject matter, they are provisions, just things that are set up in a contract itself, or trust, that disinherit any beneficiary who challenges the trust validity or terms. That's what this one was. In Ken versus Tyler, the court had to determine if Tyler's defense of the 2007 amendment fell within the scope of the no contest clause. And the clause aimed to prevent any indirect contest to the trust itself and threatening disinheritance for any violators. And they found that his actions constituted a contest, and it automatically set off, boom, it set off the no contest clause. So in the past, just so you guys know, the courts have varied in their interpretation and enforcement of no contest clauses. They've kind of been all over on that. The intent behind the clauses was to prevent the settlers' wishes and discourage that litigation that could deplete all of the estate. You can literally take an estate into court until it has no more money in it. And well, that's not a bad idea if you're receiving a benefit from that, right? Courts recognize the potential for the clauses to unjustly penalize beneficiaries with legitimate grievances. So in this particular case, the court balanced the considerations and held that the clause due to the clear evidence of undue influence. It occurs when someone exerts the pressure on the settler to alter the trust in a way that benefits them unfairly. And they found that this particular was the case in validating the 2007 amendment to that trust. And the court analysis involved examining whether defense for the amendment was a direct contest under California Probate Code section 21310 and 21311. So when and this is specific to California just because it's this particular case, but there's also, I mean, there's information available in all of these jurisdictions. Every state has its own jurisdiction. In order for someone to establish undue influence, the vulnerability, there's indicators that arise, and the vulnerability of the settler, like someone that's older, if they can be influenced into changing their mind, saying, "Oh, your intent was to do this, to leave it all to me," right? Yeah. So that age or illness or dependence on the influencer is also; those are all key factors in the vulnerability of the settler. The authority of the influencer is big as well. Whether the person exerting influence held a position of power or trust, it doesn't matter. But it is a consideration that's taken into to effect. So actions or tactics used are also indicators. So whether the influencer employed manipulative acts like isolation or emotional manipulation, those are all factors in trust. This gets really down to outside of the scope of what the legal system is. When you say legal system, I'm saying this is like what a man and a woman. This is really like, okay, one man influencing another man and coercing, and these are real equitable words. I want you guys to recognize that all of these things are the reason that we go over this, because everything I'm giving you is the important stuff. It's the nuts and the bolts. Well, how do I know this? How am I qualified to even give you guys like any sort of anything on this? Well, I have researched this subject matter since 2007. I actually ended up meeting David Merrill in 2000 and I want to say 17, 18, around there. And he was a mentor of mine for several years. And then he was doing everything in the common law because he thought that the common law was the right way to go. And I have run into other people since then, and other mentors, other people that choose not to be named, and I respect that. So they have shown me ways of researching and doing other things, and so I have implemented this, and that's what I'm turning into showing you guys, to remedies that work. They're real remedies that work, and it's because you have to know that your situation or your status isn't proper. As long as you know that, it's not right now, and you can attest to that as being a thing, then you're good. But if you don't understand that that is a thing, then you're not going to understand what this does. And you might even think that this is like not even a real thing, because I've seen that. I've seen where people just say, no, that's not real. You can't perceive something that is really equitable because of everything else you've been taught in your life. You've been taught that this is the book, and it's kind of like there's no book, right? I mean, does anyone know what your statute? I mean, okay, so maybe this is an unfair question. I'm going to say, does anybody know anybody that hasn't gotten a ticket, what your statute is for tickets in your state? You probably don't know, but if you've gotten a ticket, you probably have it memorized because you've looked it up so many times and tried to figure out how it applied to you. And when you realize that the application of that it has nothing to do with you, but it has to do with what you've agreed to do in a contract under Article 1, Section 10. And when we realize that, then we realize what our problem is. So when I realized that I was doing that and what I was bound to and how I had gotten under the obligation, then I realized that something needed to be done about it. But once you are already in a contract with the stipulations already understood, then you can't go back and change it. You have to go and resolve it. So the resolution is what I sought and what I found. And the resolution, with the help of other people, have helped me put other pieces of the puzzle together so that I can understand this enough and well enough to explain it to you guys, so that you guys can apply it to your own lives and you can move into the private as well. I don't claim anything for I don't claim any of this stuff. This isn't my knowledge. I'm sharing with you guys knowledge that's out there. It's been out there, and it's just knowledge that's been out there, but it's been hidden. And it just so happens that I've been able to discern and navigate with help. Again, I don't claim to do any of this on my own. I don't even believe we have our own ideas. I think that the ideas are out there in the world, right? I think that we feel things and we decide things based upon feelings. And so anyway, that whole thing, my evolution into this whole realm has been nothing short of a growth in spiritual awakening for myself and to help others as well. Because I realized that, I grew up in a family where my father was military. I did another video on that where, my father is a recipient of the Silver Star in 2010. And so his service in the military, I have a lot of respect for that. But also, when we realize after we get out of this or when we can start to see on the other side that all of this stuff is created so that people become a member of it, so that they become a volunteer to it, and it's not intended for our use. It's the warning said. It says for just audience discretion is advised. I mean, it's just one of those things where we have to use our own discretion whether something fits into our realm or whether it doesn't. And most of the time this stuff doesn't, but we believe that we feel compelled to take on certain things because, we see other people take them on as well. Like how can insurance not be our responsibility? Well, where's the money coming from? Do you guys ever think about that? Where is the money in insurance coming from? It's coming from your endorsement, your signature. And if it's not your signature, it's a signature that you created before that still has the ongoing power of attorney. It's pretty simple. I mean, it's not real hard, but you don't connect those dots because no one told you to think that way. So moving on, we're going to give you the background or the initial no contest clause. We're going to talk about that and how meticulous it was. Again, I talked about the vulnerability of the settler. We talked about the equity of the actions or tactics used. Okay, whether they used the influencer employed manipulative tactics such isolation or emotional manipulation, and then whether the resulting amendment disproportionately benefited the influencer at the expense of other beneficiaries. So what was the end result? And they justified that. So probable cause in trust litigation, and a significant aspect of the case, this one, was taking the assessment of whether he had probable cause to defend the trust contest petition. And based upon the facts, there wasn't reasonable basis to believe the amendment would be upheld. And so that was, the determination that was crucial in enforcing that clause. So to fully appreciate the complexities of our modern trust litigation now, we got to explore the historical precedents that shape principles that govern trust and estates today. And these cases provide insight into how courts have handled disputes over trusts and the evolution of legal doctrines. So we've talked about this, the Earl of Oxford's case in 1615. That was one of the most significant historical cases. And the case established that equity prevails over common law when there's a conflict between the two. Okay? Equity prevails over common law when there's a conflict between the two. Simple. The case involved a dispute over land and trusts, and the Court of Chancery intervened to provide a fair resolution that the common law courts couldn't give them the resolution. It laid the foundation for the maxim, equity will not suffer a wrong to be without a remedy. That's where the maxim came from. So the significance and the impact on this was it reinforced the importance of equity as a means to achieve justice where rigid common law rules couldn't get to. They fell short of it. And the case set a precedent to the courts for equitable principles to address the wrongs to ensure that outcomes were fair. And they influenced countless subsequent decisions in the trust law realm. The next one is the Duke of Norfolk's case in 1682. This case involved the creation of a shifting executory interest. Okay, a shifting executory interest. So an executor interest was shifted, a complex trust arrangement, and that's what it is, a complex trust arrangement that allowed for future transfer of property under certain conditions. So someone does this, then this property can be transferred. So it's executory. So what they're doing is they're saying that an executor were to step in as soon as certain things were triggered along the way. And that caused a lot of, it was just made it complex. That made it complex because it had to be constantly monitored. You know, it wasn't like hands-free, okay? But the use of that, it allowed for the future transfer of the property, again, under certain circumstances when things happened. The House of Lords upheld that the validity of this arrangement was valid, right? Demonstrating the flexibility and adaptability of equity and trust law. In other words, the settlor could say, yeah, you know what, this is my wishes. And equity says, yep, we're going to follow that because that was their wishes. Their intent was behind that. This case introduced the maxim equity regards as done what ought to be done. That emphasized the importance of fulfilling the settler's intentions. So this particular doctrine, or this case, exemplifies the adaptability of equity and evolving trusts and doctrines, and the meeting of new challenges and how these are overcome. By upholding the validity of complex arrangements in trust, the court here acknowledged the necessity of accommodating the settler's sophisticated estate planning strategies, paving the way for, well, modern trust structures now, because that's what they are. They have them. They're complex now, the ones that are effective. And the more you learn into this, the more it's like learning more puzzle pieces. So, and the puzzle is unlimited because it's the more stuff you can think of. It's you're the settler. Become the settler and make your wishes. Your wishes, their command. The Keech versus Stanford case was in 1726. It's Keech. And it was a foundational case in the area of fiduciary duties and trusts. So in this particular case, Keech, a trustee adopted to renew a lease for his benefit after the original lease, held in trust for a minor, expired. The court held the trustee had breached his fiduciary duty by taking advantage of his position to secure a benefit for himself. The case established the principle that trustees must act solely in the best interest of the beneficiaries. Encapsulated in the maxim, equity demands that trustees act in good faith. The principles established in Keech versus Stanford continue to underpin modern trust law. In particular, the stringent fiduciary duties that are imposed on trustees. Trustees are obligated to avoid conflicts of interest and to act with utmost good faith and loyalty towards their beneficiaries, a standard that's critical to maintaining trust and integrity in trust administration. Maxims of equity are guiding principles that courts use to ensure fair and just outcomes in legal disputes. And these maxims are particularly relevant in trust litigation, where the courts must balance the settler's intention with the rights of the beneficiaries. The maxim, equity will not suffer a wrong to be without a remedy, underscores the principle that equity seeks to provide remedy for every wrong. In trust litigation, this means that beneficiaries who are wronged by trustees' actions or undue influence should have recourse to the courts to rectify the situation. The Key versus Tyler case exemplifies this maxim as the court intervened to address the undue influence exerted on the settler. In practical terms, this maxim ensures that courts can fashion appropriate remedies to address breaches of trust, fiduciary misconduct, or other wrongs. This flexible approach allows courts to tailor solutions to the specific circumstances of each case and ensures that justice is achieved, balancing the equities between the parties. Equity regards as done what ought to be done. This maxim reflects the principle that equity treats obligations and promises as if they have been fulfilled. In the context of trusts, this means that the courts will enforce the settler's intentions as if they were already accomplished. The Duke of fulfillment is particularly important in trust litigation, where the settler's intentions are paramount. The courts rely on this maxim to enforce the terms of the trust and to ensure that beneficiaries receive the intended benefits, even if the formalities of the trust arrangement have not been strictly followed. The maxim equity demands that trustees act in good faith, emphasizes the fiduciary duty of trustees to act in the best interest of the beneficiaries. Trustees must avoid conflicts of interest and act with honesty and integrity. The Keach versus Stanford case highlights the importance of the maxim as the court held the trustees accountable for breaching his fiduciary duty. In modern trust law, the fiduciary duties of trustees have been codified, which means that they've been put into codes so that you can't see what they are. And they've been expanded to ensure the highest standards of conduct, well, on their realm, not on yours. Trustees are required to act with loyalty, prudence, and impartiality, and they safeguard the beneficiary's interest and maintain the trust's integrity. What they don't want you to do is to take control of something that they're in control of, because you don't understand what it is. It's like having the Battlestar Galactica and they're the pilots, the only pilots that know how to fly it. When people learn trust law, it's learning to fly your own outfit, and you don't have to rely on somebody else and what their understanding is. Because quite honestly, it's not them that's holding you back. It is the trust, the way that it's been written and the way that it was intended. It is a trust for land that is to be held in under a military jurisdiction that is, well, under emergency powers all the time right now. And we have to understand that. So there is implications that this case has for estate planning. So some of those, and one of them is the importance of having a clear trust provision. The Key versus Tyler case underscores the necessity of clear and unambiguous trust provisions. In other words, very, very transparent so you can see exactly what it is. So especially regarding the no contest clauses. Trusters need to ensure that intentions are explicitly stated. You guys writing wills and things like that, you need to explicitly, very, very detailed, like state to prevent future disputes and protect the integrity of trusts. Clear language helps avoid litigation and ensure that settlers' wishes are honored. And you guys, we're probably going to have a discussion sometime this week on the limitation of estates. Happy 333. It's 333 right here, right now. Anyway, we're going to have a discussion on the limitation of estates, because basically when you guys start saying, well, Johnny gets 1/3 of this land and Deborah gets 1/3 of this land and Mike gets 1/3 of this land, it should be to the people and their heirs. When you start limiting it like that, you start breaking up the estate and you start causing chaos and you don't even know it. And so you don't need to do that. You guys need to make sure that you're using effective wording when you're doing this, because it's important. I mean, this stuff is, it's important to learn because, well, it exists, and the outcome of how it comes out determines whether somebody is scraping to survive or whether they are comfortable for the rest of their life in this economic system. It just is what it is. And it's very hard to live outside of this economic system. People can refute it and say, no, I'm not doing this anymore. But the fact of the matter is you got to live somehow. And unless you're out in the woods, like, I don't know, man, it's probably not your woods anyways. If you're out in someone else's woods or someone else's land or land that is under the presumption, see, what we cannot get over, and this is never going to change, guys, what's never going to change is the corporation existing where it is and how it is. It is already set up that way. You can't go against that. What you can do is you can realize that you either fall into that section of the trust or you can create your own. And that section is the public, which is like their rules. Like, hey, when this happens, this happens. When this happens, this happens. When this happens, this happens. That's why you don't have any say in anything, because everything they've got planned is art. And I don't mean planned, like this isn't some sinister plan. I mean, what is in the Constitution, okay? Constitution is a debt. Okay, it's a debt indenture. It's a trust debt indenture. And constitutor is one who passes a debt to another. So you are a constitutee, one who received the debt. And that is using the title certificate that they've given you the way that you have, without having that, just having it out flapping in the open. Okay, imagine like, I don't know, just imagine something that flaps in the open. How about that? Imagine just something flapping in the wind out in the open, and it shouldn't be. It should be private. It should be concealed, and it's inappropriate to have it flapping in the public, okay? So if you guys can take that visual out of your head, now, if you have a trust, it's not flapping out in the public where everyone can see it. It's not indecent well, I guess that's a little too much, right? It's not considered that, though. It's not an issue where we have something that shouldn't be exposed in the public, but it is. And I'm not talking about like something you see. I'm talking about information. You sick people, get your minds out of the gutter. Get your minds seriously out of the gutter. That's disgusting. Anyways, the drafting of a no contest clause, and I'm going to talk to you guys about like how that's done, okay? Because this is what happened in that particular trust. So to draft an effective no contest clause, a truster working, of course, with a legal professional, you guys, because this is not legal advice. This is just, we're having fun. We're having fun exploring the law, right? You're going to specify the consequences of violating the clause. You're going to define what constitutes a contest, right? So you clearly define what constitutes a contest. Then you specify the consequences of violating the clause, okay? Then you ensure the clause complies with state laws and is enforceable. Then you consider including exceptions for legitimate challenges based on probable cause. Now, you guys need to wake up, because you guys are supposed to be beneficiaries. You guys are supposed to be beneficiaries, okay? You're not supposed to be trustees. You're not supposed to be subordinates in any way whatsoever, all right? You're supposed to be at the top of the echelon. You're supposed to be at the top of the food chain, guys and gals. Seriously, What's happened is through a process called alienation, which is surrendering of property. So I want you to imagine this. Imagine you had family that was around in, say, okay, because I'm going to give you a reset that occurred in the United States. I know it was a reset that occurred here, and it was in up to 1902. Well, you can look at all the books, the rewritten books, the law books, all the new stuff was rewritten, and it was actually rewritten through publishing companies that belong to the same people that are creating history. You can research all this and find it yourself, but you'll see that on the resets didn't occur everywhere, all over the whole world, all the time. They were done periodically throughout time. So imagine that you had family that was alive and they had a huge estate, and you may not even know it. I know that there's people finding all kinds of stuff, patents, land patents that are out there, that land belong to these people. People own land patents, and those land patents are in equity, guys. So what's happened is they've created a new system. Well, you read my lips earlier when I told you that equity supersedes the law, and so that is a thing. And so all of that stuff that belonged to those people still belong to their families once their families discover that this stuff even exists. And they've got you so busy in coliseums and sporting events and other things that you're never going to take the time to go find out where you come from, where your origins are. If you don't know where you came from, you don't know where you're going. And kudos to David Merrill for teaching me that, because he told me that. I remember vividly someone asking me, he said, Patrick Neal, who are you? I think I still have the email. I'll show you guys sometime. Like, he said, who are you? And I was like, it made me think. And I'm thinking, is he asking me because I'm somebody important, or is he asking me because he's testing me to see? I really didn't know at that time, but it was really a great experience to be able to go through to experience that. Like, I can't explain it. It just really was an eye-opening moment for me. And from that point in time, it was been a journey to discover, well, who am I? Who am I? Who am I? How am I? And I'll tell you, everything that all of my journey has taught me, that I am nothing that exists in this physical world. Not at all. Nothing. Not one single thing. There's a lot of junk that comes with this world. And, guys, I had a message with my kid earlier, and I said, he said, and he's just a kid, you know what I mean? He says, what are you doing? And I said, what are your plans do you have this week? I said, I'm working. He said, okay, that's right. It's Monday. Haha. I've been trying to get a new mic and some other things for myself. I said, cool. That sounds like stuff. He says, haha, yeah. I said, you are a spiritual being in a physical avatar. Things are a test made by Satan to test everyone. Just like the video explains, and he says, just like the video explains the rings and all that. So I sent him a video with Jordan Maxwell, and he was watching that. He watched that about Saturnalia and Saturn. So it was interesting that, he does pick up on stuff, and he's very wide awake, because he doesn't buy any of this stuff. And you know what? I kind of gotta, like, I don't know. I hate to, I don't have, first of all, people need to know that I don't tell him what he needs to do and what he needs to not do. I think he's old enough to do that. He's almost 18 years old. And so he can make those decisions on his own. He is very smart, and I was very influenced. So I don't even know what it's like to have a kid that's not been manipulated or influenced. And I don't mean that like, I'm a victim. I'm not a victim. I'm just saying that is what happened. And so I've worked my way out of that, but it's been a situation where it's been a little strange. And it's hard for everyone to go through a time where they believe that this is all their stuff and all this stuff belongs to them, and they're responsible for it, and then to discover that, wait a second, how did I become the surety for a stranger? Like, how did this happen? And when you start unraveling that, well, it helps. And the fact is I can help anyone, but I can help anyone that has an open mind to an alternative way, because it's different doors that open up for you. So in order for beneficiaries to avoid problems, they should review documents. They should become privy to what you guys need to become privy to trust documents. Because if you're not, then people are going to take advantage of you and walk all over you. That's the only reason I teach this on the side, because you can't just it's not something. You have to have somebody that's committed to this. And the reason that this platform even exists, the website even exists, is because where do you guys go when we get off of this? Like, we get off of this and you got to have a place to study. So that place has been, crucial for people learning and finding remedies and studying through this and getting to the next stages of correcting the record. Because once you correct a record, then things start. Like, you guys, some of you guys are just at the correcting the record part where you haven't even started yet because you don't know the next step. But we're gonna help you guys get there and show you the ways through that and how you got there if you don't understand that already, and then show you how to fix it. It's all fixable. Like, there's no negative stuff in this. Like I said, I can help anybody. I want to help everybody, but some people are hateful, and I don't help people that hate. So there's people that really need my help that are just hateful people that go and post hateful stuff and they really it's like the pot calling the kettle black oftentimes. You guys know what I mean. So we'll talk about that in momentarily. But beneficiaries can thoroughly review the trust documents. They evaluate the risks and the benefits of contesting or defending amendments. So when you're getting something, just remember, hey, you know what? Is this going to be a qualm where, if I win this, then I could get $4 million, but if I lose it, then I have nothing. And that's a bad deal. So don't do that. Just take what you can and walk away. That's what it was intended for. The person that created it didn't want controversy. And if you're going to be controversy, then you're out. Simple. You're fired. Okay? So consider alternative dispute resolution methods like mediation or to resolve conflicts in your own and without triggering that no contest clause. So you guys can also choose mediation instead of triggering that clause or coming out and saying you can send private mediation. That's a deal. That's a real deal. That's a real thing. So precedents that were set by this case and the appellate court's ruling in Key versus Tyler demonstrated the court's willingness to enforce no contest clauses and to scrutinize amendments obtained through undue influence. And the decision reinforced the need for trusters to draft robust and clear trust documents. So instead of just leaving it ambiguous with precatory language, precatory, P-R-E-C-A-T-O-R-Y, it was making them very clear. Courts were likely to continue scrutinizing trust documents, particularly under suspicious circumstances. Trusters and beneficiaries need to be aware of the high standards of evidence required to prove undue influence or other misconduct, ensuring that all trust-related actions are well documented and transparent. So trusters should seek legal advice to create comprehensive trust documents that minimize the risk of disputes. It includes drafting clear and enforceable no contest clauses and ensuring that amendments are properly documented and executed without undue influence. Sometimes you guys can give information on what you want to an attorney, and they'll draft a part of it for you without taking your rights away. So that's what you really want to do, is learn what your rights are and then learn what the clauses say. And I show you guys in the classes as well. So I teach this stuff and I show you guys in examples, and I've used some of this stuff in some of the pleadings that I've shown examples of. So the truster's effectiveness can be enhanced by estate planning, and that's done by articulating intentions in the documents, giving detailed provisions on the administration of trust and distribution of the assets, and to regularly review and to update the trust to reflect the changes in the circumstances and the laws and the times. If somebody died and they're no longer able to benefit from it, then you need to remove them from the beneficiary list, right? or unless there's some sort of clause that allows their heirs to have that. It just depends. I mean, that's something that is important to look at. So the other thing is trusters communicate the estate plans to the beneficiaries to prevent misunderstandings and to prevent disputes. So the key Tyler case lessons are: trust documents need to be clear and precise to avoid ambiguities that lead to disputes. Trusters and beneficiaries should seek legal guidance in rights and obligations, or understand them, at least research them on your own. Proper documentation and evidence are crucial in trust litigation, particularly involving allegations of undue influence. So when you got something complex, you're going to need good records. Trustees uphold fiduciary duties with utmost integrity and avoid actions that compromise the beneficiary's interests. So this is a synopsis, basically, of the entire discussion that I wanted to talk about this. What I do want to talk about here, though, is something very, very important. And this discussion is going to be on equitable maxims again. Why it's crucial to come into any situation with clean hands. And I'm excited to share this stuff with you guys because it really means a lot. But equitable maxims are fundamental principles that ensure fairness and justice in any situation. And one of the most important ones is he who comes into equity must come with clean hands. And simply said, it means that if you want to be treated fairly, you need to act fairly yourself. So the idea of clean hands means that if you're seeking help or fairness, you shouldn't be guilty of any wrongdoing related to the issue. You can't expect to receive fair treatment if you hadn't acted fairly. It's all about integrity and good faith. To bring this to life, think about situations where someone tries to tarnish your reputation unfairly. Maybe they spread false rumors about you on a post, disparaging comments online. This kind of behavior shows that they don't have clean hands, especially if they're trying to deflect attention from their own mistakes. Take a look at this kind of social media post. It's an attack on someone's character, calling them names or trying to make them look bad. Actions like this are not only unfair, but also show a clear lack of integrity. So why do clean hands matter? Because fairness and justice depend on everyone acting with integrity, whether it's in legal situations, at work, or in personal relationships. It's crucial to be honest and fair to yourself and your others around you. Be fair to yourself. Be honest to yourself. When you're seeking fairness, whether it's from a boss, a friend, or even in court, it's important to show you've acted honorably. This way, the focus stays on the real issues, not on any potential misconduct on your part. Now let's talk about why people with dirty hands often try to bring others down. This behavior can be often explained through psychological analysis. Now, I am not a doctor or any other professional like that, but I'm going to tell you that this is just true, and you can prove me wrong. You're welcome to leave a message in the comments. Disparaging others is a common tactic used by people who feel vulnerable or guilty. When they are facing criticism or consequences for their actions, they might try to undermine someone else's credibility. It's known as projection. Projection involves blaming someone else for your own faults. By calling someone a liar or a thief, they're trying to shift the focus away from their own behavior. It's a way to deflect attention and criticism. This tactic also helps them feel more in control. By attacking someone else, they create a story where they are the victim, hoping to gain sympathy and support from others, and hoping to gain other victims to join them in their, or other victims, should I say. People just are looking for somebody to blame. Let me tell you something, guys. I had somebody that went on and said something about, well, this is end times, and Revelation says, go look up. It says about anybody that's affiliated with a wolf. Oh my gosh. Okay, lady. First of all, your name, what was her name? It was weird, guys. It was strange. It was, I don't want to say, I'm not going to say it on air, but it was like a part of another word that looked like a bad word. And I said, because your name looks like that bad word, I don't say that that's you. It isn't you, right? Like, I've never met these people. Seriously, I don't understand. I've never met these people. And some of these people come and ask me for information. And then they go and spread the hate again. And they forgot that they friended me and they asked to be my friend and were taking my information. And now they're spreading hate. So it's all good. I mean, it is what it is. People show their true colors. And this is a great time to be alive. So it's important to respond to this kind of behavior with integrity and professionalism. Engaging in a public feud or responding with similar attacks only lowers your own standing. Instead, keeping your cool and focusing on the facts and principles involved is what the resolution is. When we're faced with unfair attacks, take the high road. Maintain your integrity and stick to the truth. By doing this, you show you're acting with clean hands, which strengthens your position and credibility. Conclusively, understanding equitable maxims and the importance of clean hands is the key to ensuring fairness in any situation. Acting with integrity not only helps you stand firm, but it also ensures that justice is served. I want to thank you guys, all of you, for coming out and joining us in this discussion. And if you have any questions or comments, feel free to leave them below. Remember, always strive to act in honor and integrity with all respects in life, and stay informed, stay just, and stay committed to service and fairness. And I appreciate you guys very much. If you have any questions or you guys just left it. Yeah. So the lady's name, yeah, that's what it was. Her last name is W-I-C-H. Okay. So I said, well, because your last name is Witch doesn't mean I think you're a witch, right? The whole point was that anybody that has an affiliation to do, well, let me tell you guys the story really fast, and then we'll conclude this. So a nickname was given to me a long time ago because somebody always wondered why I went out and did my own thing, and I didn't trust people, and I didn't understand why I didn't do that. Actually, I didn't even know that I didn't do that. I just always thought that I was doing what I had to do. And when I was confronted with that, I didn't have an answer because they were right. And when they said, "You're a lone wolf," and I said, they said it respectfully in a way that I was a person who knew that I wasn't going to get answers in the public, and I wasn't going to get answers from anyone else. I was only going to get answers from inside of my heart. And the only way that I would do that is my time alone, my own time alone. So many of these things, when people, often people rely on other people and they want to, have other people by their side to do it. I was just the opposite. I went in, did this all by myself. And sometimes I didn't talk to people for, well, I mean, you guys know what my history was, my story was, how I was incarcerated myself. And so when it comes to those kind of things, you're humbled by each one of those events, or at least many people are. And I was one of those. I'm one of those that is very humbled by those things that happened to me. And I don't take anything in this life for granted. I respect every moment, every situation, every circumstance, good or bad. So, that's, as far as the lone wolf thing goes, it has nothing to do with a wolf is a fighter and a survivor. And a lone person is one that is by themselves. They're not with others. So a lone survivor is what you could say a lone wolf is. It's a lone survivor, even though, people will come and go, but the only thing you have is your body, your mind, and your spirit. That's it. And if you don't have those balanced, then you have problems, and no one else is going to help you. And if anyone does help you, it's an illusion, because once they're gone, you're going to fall on your face. That is the illusion that we live in. If you want to maintain that illusion and stay in that illusion, then you maintain and stay in being a ward of the state. If you don't, then you have things you need to fix. And we invite you to come over and join what we do, because we appreciate you guys very much. And I don't think that woman is a witch any more than anybody thinks that I'm a wolf. Okay, so anyway, I am like, as I got my dog, you guys, my dog is pretty amazing. So I am part dog, so wolf, You guys have an amazing day. I appreciate you very much. And with that, I yield.